My name is Mira Vasquez. I am 27 years old. I work in product design and hold 3 patents, and I found out my sister had built her entire company around something I invented when I saw my own design on the front page of a business magazine with her name underneath it. Not my name. Hers. Catalina Vasquez, founder, innovator, the sister who'd made it. Smiling, confident, holding up a product I had sketched on a napkin in our mother's kitchen 4 years earlier, presenting it to the world as though it had sprung fully formed from her own imagination. I was sitting in a dentist's waiting room when I saw it. I want you to know that, because it matters, the most important moment of my adult life happened under fluorescent lights while I was waiting to get a filling, holding a magazine I'd picked up out of boredom, and my sister's face was on it, and the product she was holding was mine. I did not call her. I did not throw the magazine. I have spent my career watching ideas move through the patent system, and I have learned the most important thing that work teaches. The person who reacts emotionally to an intellectual property theft becomes the person the room decides is jealous, and the jealous person never wins. I sat very still, and I read the article to the end, and I let my sister believe, for a little while longer, that the quiet sister who doodled for a living would never notice, or, if she noticed, would never be able to prove it. And I read it carefully, the way I read a patent claim, looking for the specifics, the technical language, the description of the mechanism. And there it was, in the magazine's glossy prose, my own design described in language that was close enough to my patent claims that I could have annotated the article with claim numbers. The journalist who wrote the piece didn't know it. The photographer who shot Catalina holding the product didn't know it. The readers who would see it and think what a brilliant founder didn't know it. But I knew, sitting in that plastic chair with a toothache, that my sister's entire public identity was built on 47 claims I had written, filed, and been granted, in a document she had never bothered to read. Because my sister had made one enormous mistake, and she made it because she'd spent our whole lives thinking of me as the dreamer, the artist, the one with the sketchbook and no business sense, too creative and too impractical to ever be a threat. She didn't know I'd filed the patent. She didn't know that 3 years before she launched her company, I had taken the design she was now calling hers to a patent attorney and done the boring, unglamorous, expensive, invisible thing that artists almost never do. I'd protected it. Properly. Legally. In a form that the United States Patent and Trademark Office had reviewed, approved, and granted, a form that meant the design belonged to me, irrevocably, in the most airtight way the law provides, regardless of whose face was on the magazine. Before I tell you what happened when my sister's company received a cease and desist letter from my attorney, and what I chose to do when I finally held every card, tell me what time it is where you are right now, and whether you've ever watched someone take credit for the thing you made. I want to see how far this story travels. I have to explain what I do, because it's the whole spine of this story, and it's the exact thing my family treated as a hobby rather than a profession. I'm a product designer. I design physical products, the shape, the function, the mechanism, the thing that makes a product actually work in someone's hand. It is deeply technical work disguised as creativity, and that disguise is the reason my family never took it seriously. When I tried to explain what I did at dinner, my mother heard she draws things and my sister heard she doodles. Neither of them understood that the sketch on the napkin was not a doodle. It was an invention, a specific, novel, functional solution to a problem that no existing product had solved, and it had taken me months of iteration, prototyping, and testing to get right. The napkin is important. For years before that magazine, I was home for the holidays, and I was working on a design problem that had been nagging me, and I sat at Mom's kitchen table and I sketched it out, thinking out loud, the way designers do. Catalina was there. She watched. She asked questions, good ones, actually, because Catalina is smart, and I've never denied that. And then the holidays ended and we went back to our lives, and I kept working on the design, and I filed the patent, and I assumed my sister had forgotten about a sketch on a napkin, the way you forget about anything that happens at your mother's kitchen table. She had not forgotten. She had photographed it. I found that out later. She'd taken a picture of the napkin sketch with her phone while I was in the bathroom. And over the next 2 years, while I was doing the slow, unglamorous work of refining the design and filing the patent and building prototypes in my apartment with no money and no help, my sister was doing something else entirely. She was taking my concept, the photograph on her phone, and she was finding manufacturers, and investors, and branding people, and she was building a company around it, and she was doing all of it without ever once mentioning where the idea had come from. She had taken the seed I'd planted on a napkin and she had grown it into a business, and she had carefully, completely, erased the napkin. I should describe how she did it, because it tells you who my sister is. She didn't photocopy my patent filing or hack into my attorney's files. She took a photograph of a napkin and she handed it to a product development firm and she said, "I have this concept." She said I. And from that single pronoun, a company grew. The development firm refined my design, they made it manufacturable, which is real work, but the core innovation, the mechanism that makes the product fundamentally different from anything else on the market, was the thing on the napkin. Everything the development firm did was iteration on my invention. Catalina had paid smart people to polish someone else's idea, and she'd called the polishing invention, and nobody in the room had ever asked where the idea came from, because in a room full of business people, the person who walks in with the concept and the checkbook is assumed to be the originator. Nobody asks for the napkin. And here is the thing that made it not just theft but a specific kind of erasure. Catalina didn't just use my design. She improved it, or rather, she paid people to improve it, and every improvement made it harder to see the napkin underneath. Layer by layer, refinement by refinement, the product moved further from the sketch and closer to something that looked original, the way a building moves further from its foundation with every floor. But the foundation is still there. The foundation is always there. And the foundation was my 47 patent claims, and no amount of floors built on top of them changed who owned the ground. I want to be fair, because fairness is the whole point of this story. Catalina did real work. She built a supply chain, she found investors, she branded it, she sold it. Those are real skills, and they matter, and I won't pretend they don't. What she did not do, the thing she could not do, was invent the product. The thing that made her company exist, the core innovation that every investor was excited about, the design that made the product different from everything else on the market, that was mine. She built a beautiful house on someone else's foundation, and she'd been so busy performing ownership that she'd forgotten the foundation was a person. There were 3 moments I never let myself feel until that dentist's waiting room made me feel all of them at once. When I was 23 and showed Catalina my first granted patent, a different design, an earlier one, she said, "Oh, that's cute. Is that like a trademark?" She did not know the difference between a patent and a trademark, and she did not care enough to ask, and I realized in that moment that my sister's understanding of what I did stopped at "she draws things." When I was 25 and the patent for the kitchen table design was granted, I mentioned it at a family dinner, and my mother said, "That's nice, dear," and Catalina changed the subject to her new company, and nobody asked me what the patent was for, and I didn't push it, because I'd learned that claiming credit in my family was treated as bragging and bragging was ungracious. And 6 months before the magazine, when Catalina's company was getting its first real press and the product was clearly, obviously, unmistakably based on my design, I called her, the one time I broke my silence, and I said, carefully, "Cat, that product looks a lot like something I designed," and she laughed and said, "Mira, everyone has ideas. I'm the one who actually did something with it. Everyone has ideas." As though the patent sitting in my desk drawer was an idea rather than a granted intellectual property right recognized by the federal government. And the worst part is that I knew, even then, that I should tell her. I should have said, at that dinner, "Catalina, I filed a patent on that design, and you need to know that before you build on it." But I didn't, partly because I'd trained myself not to claim things in a family that punished claiming, and partly because I genuinely didn't believe she'd use it. I thought the napkin was forgotten. I thought my sister, whatever her flaws, would not build a company on her little sister's work without asking. That belief was wrong, and the wrongness of it is something I carry, because it means I underestimated my own sister's capacity to take what wasn't hers just as completely as she underestimated my capacity to protect it. Each moment was warm on the surface. That was the trap. Each one taught me the same lesson, that in my family, the person who builds the visible thing gets the credit, and the person who invents the invisible thing is the person with the cute hobby. The artist. The doodler. The one who has ideas. Then I saw my own invention on a magazine cover with her name on it, and the gap between what she'd built and what I owned became a legal canyon she was about to fall into. Let me tell you about the patent, because it's the whole thing and my sister never understood it. A patent is not a piece of paper that says you thought of something. It is a legal right, granted by the government, that gives you exclusive ownership of an invention. It means no one can make, sell, or use your design without your permission. Not your competitor. Not your investor. Not your sister. When I filed that patent 3 years before Catalina launched her company, I did the thing artists almost never do. I treated my creation not as a beautiful idea but as a valuable asset, and I protected it the way you protect a valuable asset, with the law. I did it because my boring, unglamorous understanding of intellectual property, the thing my family called the paperwork side of art, had taught me that ideas without protection are ideas anyone can take, and that the only thing that separates the inventor from the person who takes the invention is whether the inventor bothered to file. So I filed. At 24, with almost no money, I scraped together the filing fees and the patent attorney's cost, and I submitted my design to the USPTO, and after a year of examination and revision, I received a granted patent with my name on it, Mira Vasquez, inventor, with a priority date that predated anything my sister would ever produce by 3 full years. That priority date is the whole story. It means my ownership is established, on the record, before Catalina's company existed. Before her first investor, before her first sale, before her face on a magazine. The patent doesn't prove I had the idea, it proves I owned the design, legally, first, and that everything my sister built afterward was built on something that belonged to me. And she had no idea. Because she had never, in her entire life, taken 10 minutes to understand what a patent is or what it does. She thought I had filed paperwork. She didn't understand I had filed a wall. I want to describe what the year between the napkin and the granted patent actually looked like, because my sister skipped it entirely and it's the whole difference between us. After that holiday, I went back to my apartment and I started working. Not doodling. Working. I iterated the design 14 times. I built 3 physical prototypes out of materials I bought at a hardware store. I tested them, broke them, redesigned them, tested them again. I sat with a patent attorney for 4 hours going through prior art, every existing product that did anything similar, to make sure my design was genuinely novel and not just a variation of something that already existed. I revised my claims, the legal language that defines exactly what the patent protects, 3 times, because the claims are the wall and a weak claim is a wall with holes. And I paid for it, the filing fees, the attorney, the prototypes, out of a salary my family thought was barely enough to cover rent. None of this was visible. None of it was glamorous. Nobody put my face on a magazine for sitting in an apartment for a year making something work. But that invisible year is the thing the patent protects, and it's the thing my sister never did, and it's why the law says the design is mine. Here is what I did after the dentist's office, and here is what I did not do. I did not call Catalina. I did not post. I did not leak to the press that the celebrated founder's core product was her little sister's patented design. I went home, and I pulled my patent from the desk drawer, and I sat with it, and I did the thing my whole career had trained me to do. I documented the situation carefully, assembled the evidence, and then I contacted my patent attorney. She reviewed the product, Catalina's product, the one on the magazine, against my granted patent, and the analysis took about 30 minutes, because the match was not subtle. The core design, the functional mechanism, the specific innovation that made the product work, all of it fell within the claims of my patent. My attorney's professional assessment, delivered in the flat, inarguable language of patent law, was that my sister's company was manufacturing and selling a product that infringed my intellectual property rights. And then she asked me what I wanted to do. This is the moment the story pauses, because the answer to that question is the whole point. Here is where the story becomes a choice, and it is not the choice my family expected, and it is probably not the one you'd expect either. Because I had everything. I had a granted patent with a priority date 3 years before her company existed. I had clear infringement. I had an attorney ready to file. I could have sought an injunction, a court order stopping her from selling the product entirely, which would have shut her company down overnight. I could have sued for damages, every dollar she'd made selling a product she didn't own the rights to, plus penalties. I could have gone to the press, which would have loved the story. Celebrated female founder turns out to have stolen her product from her own little sister. Catalina's company, her reputation, her investors, her magazine cover, I could have taken all of it, and I would have been legally, completely, unimpeachably in the right. I thought about it. Sitting at my desk with the patent in one hand and my attorney's assessment in the other, I thought about it seriously, because 4 years of watching my sister build fame and wealth on my invention while calling me the doodler had built up something I could feel in my jaw. But I kept asking what I actually wanted underneath the anger, and it wasn't Catalina's destruction. It was credit. Not fame, not a magazine cover, just the truth, on the record, that the design was mine, and that whatever happened next would happen with my name where it belonged. I already had that, the patent had always had my name on it. Destroying Catalina's company wouldn't give me more credit. It would just make me the sister who burned everything down, and it would put her employees out of work, and it would end something that was, in its execution if not its origin, genuinely well built. The craving to watch it collapse and the need to be acknowledged as the inventor were two different things, and I was, even at 27, old enough to tell them apart. There was also something practical the anger didn't want to acknowledge. Catalina's company had 23 employees. I knew that because I'd read the article thoroughly, because I am a person who reads things thoroughly. 23 people who had jobs because my sister had built a company around a thing I'd made, and who had done nothing wrong, and who would be out of work overnight if I sought an injunction. My patent gave me the legal right to shut the company down. It did not give me the moral right to destroy the livelihoods of 23 strangers who'd never heard of a napkin. The craving to burn it was about Catalina. The consequences would fall on people who weren't Catalina. And I was not willing to use innocent people as kindling for a family fire. So I did the thing that was harder and quieter and, in the long run, more devastating to my sister's self-image than any lawsuit. I had my attorney send a cease and desist letter, not to the press, not to her investors, just to Catalina, privately, informing her that the core design of her product was covered by my patent, and that continued production and sale without a license from me constituted infringement. And in the letter, I offered her a choice. She could license the design from me, formally, with my name attached as the inventor and patent holder, and her company could continue operating, or she could refuse, and the next letter would come from a federal court. I want to describe what that letter felt like to send, because it wasn't triumph. It was the closing of a door I'd left open for 4 years hoping my sister would walk through it honestly. Every day between the napkin and the letter was a day I'd waited for Catalina to call me and say, "Hey, remember that sketch? I'm building something from it. Can we talk?" She never called. She never asked. She built a company, hired 23 people, got on a magazine cover, and called herself an innovator, and at no point in 4 years did she pick up the phone and say 2 words to the person who'd drawn the thing in her kitchen. The cease and desist wasn't punishment. It was the first honest sentence in a conversation she should have started 4 years ago. I didn't ask for the company. I didn't ask her to shut down. I asked for the one thing she'd taken from me, my name on the thing I'd made. She called me 20 minutes after her lawyer read her the letter. "You patented it," she said. And the disbelief in her voice was genuine, not performed, not strategic, genuinely unable to process that the doodler, the dreamer, the sister with the sketchbook, had done the coldest, most businesslike, most strategically devastating thing a creator can do. She had photographed my napkin and built a company on it, and it had never once occurred to her that the sister she'd dismissed as impractical might be the one person who understood, better than Catalina ever would, that an unprotected idea is an idea anyone can take. "You can't patent a napkin sketch," she said. And I said, I didn't patent a napkin sketch. I refined the design for a year, I built prototypes, I filed a utility patent application, and the USPTO granted it. The patent number is in the letter. It predates your company by 3 years. Your attorney can verify it in about 10 minutes. She was quiet for a long time. I could hear her doing the math, the company, the investors, the magazine, the 23 employees, all of it suddenly resting on a piece of paper in her little sister's desk drawer. And then she said, very quietly, "What do you want?" And the way she said it, braced, defensive, already preparing to fight or to pay, told me she had expected this moment for 4 years, somewhere underneath the performance. She had known, the whole time, that the design was mine. She had known, and she had built on it anyway, betting that the dreamer would never do the practical thing, that the doodler would never file, that little Mira would just understand. She was right about everything except the filing. And the filing was everything. There was a long silence. And then she said the thing I'd been waiting 4 years to hear her say without the laugh, but it was just an idea. And I said the sentence I'd say again exactly the same way. I said, it was never just an idea, Catalina. It was my invention. You photographed it off a napkin in Mom's kitchen and you built a company on it and you never once asked me, and you called me the doodler while you sold what I made. The patent isn't the revenge. The patent is just the record of who actually made the thing. All it does is say what was always true. The license negotiation took 3 weeks. Catalina's lawyers pushed back, tested the patent, looked for holes, and found none, because I had filed it properly, because I am a person who understands intellectual property, because the thing my family called the paperwork side of art was, in fact, the most airtight form of legal protection available. The final agreement, Catalina's company licenses my design from me. My name appears, publicly, as the patent holder and original designer, on the product packaging, on the website, in the company's IP disclosures. A licensing fee, structured as a percentage of revenue, flows to me for as long as the product is sold. The company continues to operate. Nobody loses their job. Nothing shuts down. I got my name on the thing I made. That's all I ever wanted. The money matters, I won't pretend it doesn't, but it's the name that mattered more, because the name is the truth, and the truth, once it's on the record, doesn't need me to defend it anymore. The 18 months after that were not dramatic. That's the part these stories never show. Catalina and I did not become best friends. But something shifted when her company's packaging started carrying my name as the patent holder, because the story she'd been telling, Catalina the innovator, Catalina the founder who thought of everything, could no longer hold. Every investor meeting, every press mention, every new product page carried a quiet footnote, patent held by Mira Vasquez. She couldn't erase the napkin anymore. It was in the legal fine print of her own company, and it would be there for as long as the patent was in force. She called me once, about 6 months in, and she said, "People keep asking about you. The investors, the press. They want to know who the patent holder is." And I said, "What do you tell them?" And she was quiet, and then she said, "I tell them you're my sister. And that you designed it." It was the first time she'd ever said those words in that order, and I let them sit without building on them, because some sentences need room. My mother took the longest, because she had the most to unbuild. Her whole understanding of her daughters, Catalina the business mind, Mira the dreamer, did not survive learning that the dreamer's doodle was the legally protected foundation the business mind's entire company was standing on. She called me one Sunday and said, "I've been telling people you draw things. And I said I knew. And she said, you invented things. And then you protected them. And I called it doodling. It wasn't an apology. But it was my mother seeing, for the first time, the difference between drawing and inventing, and I decided to let it be enough. She stopped calling me the dreamer after that. She stopped using the word doodle. She started, awkwardly, haltingly, referring to what I do as design and IP work, which was technically accurate and emotionally insufficient, but I'll take it, because a sister who can't quite bring herself to say she invented the thing my company sells, but has stopped actively denying it, is a sister who's moving in the right direction, even if she's moving slowly. Catalina came to my apartment once, about 4 months after the license was signed, and she stood in my workroom, the room where I'd built the prototypes, where the wall was still covered in iteration sketches, 14 versions of the same design getting progressively closer to the thing she'd put on a magazine cover, and she looked at the wall for a long time. Then she said, very quietly, I thought it was just the napkin. And I said, it was never just the napkin. And she stood there looking at 14 versions of work she'd never known existed, and I think that was the moment she finally understood the difference between having an idea and inventing something, that invention is not the spark. It's the 1,000 hours after the spark that nobody photographs, and that she had skipped all of them and called herself the inventor, and the wall she was looking at was the proof of what she'd skipped. There was one afternoon I keep coming back to. Catalina's company had a product launch for a new variation, still based on my original design, still under the license, and for the first time, I was invited. Not as the sister. As the designer. And at one point in the event, an investor came up to me and said, you're the patent holder? The original designer? And I said yes. And he said, your sister told me this design changed the market. She said it was the best thing she'd ever worked with. And I stood there in a room full of people who finally knew my name, holding a drink I hadn't paid for, and I felt something I hadn't felt in 4 years, which was simply seen. Not celebrated, not lionized. Just seen as the person who'd made the thing, by people who now knew. People asked me whether it was revenge. I didn't steal anyone's company. I didn't photograph anyone's work off a napkin and build a business on it. I didn't erase anyone's name from the thing they made. I didn't do a single one of the things the setup seems to promise. Catalina did the taking. Her own company's IP disclosures did the correcting, and a patent, filed 3 years before she launched, by the sister she called a doodler, did what no argument of mine ever could have. All I did was the thing my profession taught me, the thing no one in my family respected. I protected my work. Not with a fight, not with a lawsuit I didn't need to file, not with a press leak that would have felt satisfying for a week. With a filing. With the boring, invisible, unglamorous act of treating my own creation as something worth protecting before anyone else told me it was. The patent was always mine. All I did was show it to the one person who needed to see it. Here is what everybody lost. Catalina lost the story, the one where she was the innovator who'd thought of everything. She lost it to a patent number, printed on her own product's packaging, that said otherwise. But she kept the company, and the product, and the sister who could have taken it all and chose to put her name on it instead. My mother lost the tidy version of her daughters, and she's still adjusting to the fact that the one she called the dreamer was the one who understood, better than anyone, how to make a dream into something the law would defend. And I lost something too, and it wasn't Catalina. I lost the belief that making something good would be enough, that the quality of the design, and the work I'd put into it, and the fact that I'd been first, would speak for itself. It didn't. Invention doesn't speak. The record speaks. And the record only exists if you do the boring thing and file it. I keep the napkin in a frame on my desk now. Not the patent, that's filed where it belongs. The napkin, the original sketch, in my handwriting, from Mom's kitchen table. Because that napkin is the thing that was actually true. My sister could photograph it, build on it, put her face on a magazine over it. She could not, in the end, argue with a priority date. They called me the doodler. It turned out the doodler was the only one who understood that an idea without a patent is just a gift to whoever moves first, and who made sure, quietly, 3 years before her sister moved at all, that the gift had already been claimed. So if there's someone in your life who's taken the thing you made and called it theirs, who's built a career or a company or a reputation on something that started in your hands, counting on the fact that you're too much of a dreamer to know how to fight back, ask yourself one thing tonight. Have you filed? Have you done the boring, unglamorous, invisible thing that turns an idea into a right? Because the person who files owns the truth, and the person who doesn't file owns a story, and stories can be rewritten, but a patent number can't. Thank you for staying with this story to the end. Every character and event in it is fictional, written for reflection and entertainment. But if any of it felt familiar, I hope it leaves you with this: protect your work. Not after someone takes it. Before. The record is the only thing that holds, and the person who makes it is very often the quiet one, the dreamer, the doodler, the one nobody watches, building the wall nobody can see, until the day it matters.